Good evening, everybody. Now, even though you're muted, please say good evening so we know that we're all here together. This is good. Okay, thanks.
Yes, hello. Good evening.
You're welcome. I want to acknowledge, again, Rabbi Kurtz, who is here, who's been very supportive for all the adult education programming. Thanks for all you're doing, as well as Toby Schaefer, who is president, serves as a beacon of adult education growth in the community. Thank you. I also want to acknowledge Rabbi Shimi Trencher, who's the head of the upper school at the Bicultural Hebrew Academy. And it's wonderful for all the work that you're doing in the community as well. Last week, we had the opportunity to hear Rabbi Shlomo Weissman. I'm not going to go through another intro because he's a man at this point in Stanford that needs little introduction. But I have to say to you, Rabbi Weissman, your shir was very articulate, informative, and enlightening last week, and I think really made a difference in people thinking about halachic estate planning. I know I've received a number of questions from it, and in many ways, what you share with us is really what the Torah is all about, which is to try to connect it to the modern world in which we're living with the timeless principles. We didn't exactly plan it this way, but this week is Parsha Mishpatim, and the very essence, I'm probably not stealing your thunder, I hope, but at the very beginning of this week's Parsha, it says in regard to the Mishpatim, first, Ve'ela HaMishpatim. We have the letter Vav, and the letter Vav there connecting the Sinai experience to the judicial system points out that the judicial system that we have is very much rooted in divine law, in God's perspective on what justice is all about, but also the idea of Ve'ela Mishpatim Asher Tasim Lifnehem. That when we have issues of conflict, we should make sure to resolve them lifnehem, before a Jewish court, as opposed to going to a secular court. So tonight's topic really addresses that issue of litigation in Beit Din, commercial cases in a Beit Din, and the Beit Din of America is really the premier address for people to resolve matters within the Jewish community. We've used them actually in a Good at Shalom a number of times over the years. And I want to thank you, Rabbi Weissman, again for your time and for offering a presentation this evening. Rabbi Weissman will speak for about 3 hours. Then we'll have an hour of questions. Just kidding. He's going to speak for about 40 minutes, and then we'll have some Q&A. So without further ado, Rabbi Weissman.
Okay. Thank you very much, Rabbi Cohen. Thank you all for joining again, and thanks for having me back. It's a pleasure. I enjoyed last week, and hopefully we could learn again a little more this evening. As Rabbi Cohen mentioned, it's this week's parsha from which we learn the preference, or even the preference for adjudicating disputes in Beit Din, even the prohibition of litigating disputes, generally speaking, with some exceptions, in secular court. And what I wanted to focus on this evening was how are cases actually decided in Beit Din. To what extent does Jewish law come into play? Is there an element of secular law that comes into play as well? That's an important question because there's some unease, I think many misconceptions among people out there, to what extent Beit Din just kind of splits the baby to try to be fair to everyone, to what extent it's entirely guided by Jewish law, to what extent it might be guided by secular law. So I wanted to talk about some of these principles. I could start off by assuring you that at least at the Beit Din of America, where I practice, when we hear cases, the answer is not that you split the baby or split the amount to make everyone happy. And nothing like that is. Nothing could be farther from the truth. We decide cases on the merits. We call it as it is. But even so, the question then that we'll get into tonight, and I hopefully explore through some of the sources and with some examples, is what's the body of law that we bring into play? To what extent does equity play a role? Do we depart from the letter of the law, etc.? So let me start off by saying, on a very simple level, on the simplest level, cases in Beit Din, as you'd expect, are decided based on Jewish law, based on halacha, as developed originally in the Torah and then the Talmud, and then through the Middle Ages by the Rishonim, and then by the response to literature. The Shulchan Aruch obviously plays a big role because that's the codification of Jewish law. And so the entire corpus of Jewish law, of halacha, and especially the corpus of Jewish law as articulated in Choshen Mishpat, which is the section of Jewish law that relates to commercial matters, is the first place that we look, and the first place where you could expect the answer to lie to a particular question or controversy that arises in a Beit Din. So let's just illustrate that with a very simple case that we heard a few years ago. We were dealing with a dispute between a customer and a kitchen cabinet dealer. The guy was renovating his kitchen. He bought kitchen cabinets from a salesperson from a cabinet dealer. He gets his delivery of kitchen cabinets, and there's some kind of defect in the kitchen cabinets. But he's in a huge rush, and he tells his contractor, don't look too closely at the kitchen cabinets, or I don't know what he said to the contractor, but the ends up being that the story is that the kitchen cabinets actually get installed in the kitchen before he notices the defect or before he cares to look very hard at the defects. And then he calls the cabinet guy and says, I want my money back, or I want you to come replace the cabinets. And the cabinet guy says, you were supposed to check for the defects before you drilled holes in the back of the cabinets and installed them. It's too late. You took delivery. You didn't raise the issue before. I would have been happy to address your concerns when they were still in the package or not yet installed, but it's too late. So this is not the world's most difficult case. And as you can imagine, well, let's actually look. We'll look at an excerpt from the decision that we issued. Actually, Rabbi Cohen, are you able to give me? Thank you.
You should be good now.
Okay, great, thank you. Okay, so this is a excerpt from the decision that we issued. And as you could see, it cites purely to halacha. This is really the beginning and the end of the decision. I'm trying to move my Zoom window so I can read it myself. We write here, a purchaser generally has the right to return defective merchandise that has not been used. Again, it's defective, so you'd expect that he has the right to return it, but that assumes that it has not been used, with the citation to Shulchan Aruch Choshen Mishpat 232.3. A purchaser who uses the merchandise after discovering the defect is deemed to have waived his right to return the merchandise, again, citing to that same part of Shulchan Aruch. Most authorities extend this deemed waiver to cases where the purchaser could easily have inspected the merchandise but decided not to do so. So I guess that's this case, because here's a guy who put the merchandise, he installed it, he put his drill holes in the back, he could have inspected it, but he decided not to do so. If you read the footnote again, it cites to the Sma, which is one of the Nosei Kelim on the Shulchan Aruch. It appears on the side of the Shulchan Aruch. It's a commentary to the Shulchan Aruch. Rabbi Falk, the Sma, citing the Magid Mishnah. See also Pischei Choshen, which is a more contemporary work of Jewish monetary law, accompanying footnotes. One issue that's relevant to the discussion in notes in the footnote here is in the accompanying footnotes there on the Pischei Choshen is how discernible the defects are, meaning is this a hidden defect that you to expect that it only becomes apparent later on. In this case, a simple inspection of the cabinets prior to installation would have revealed the chips in the cabinets. And so then back on top, in this case, defendant decided to have his contractor install the cabinets as is without inspection, thereby waived any rights to later seek a credit against the cost of the cabinets for whatever defects might have been present upon delivery. So it's a fairly straightforward assessment, but as you can see, as you would expect, a rabbinical court looks at Shulchan Aruch and applies the black letter law to a pretty straightforward set of facts. But what I'd like to do now is kind of go beyond that, because in many instances, secular law does have a role to play in Beit Din jurisprudence. And very often, the dayanim who sit on the cases will look to secular law or will ask the parties to brief us on secular law. Now, I'll just point out that at the Beth Din of America, one of the things that's unique about the Beth Din of America is that on virtually every commercial case that we hear, there's at least one lawyer who's a member of the panel. That lawyer might be someone who is exclusively a lawyer, someone who really his whole career might have been in the law, or it might be someone who has rabbinic training as well as legal training. We have a few of those. That's myself included. I have a law degree as well as smicha, and so we kind of have that mixed expertise. But on any given panel, we'll kind of mix up the expertise. There will be two rabbis and a lawyer, or one lawyer rabbi and two rabbis. Depending on the level of complexity of the case and the type of controversy it is, that will determine how we staff the case. And so, at least at the Beth of America, delving into the secular law is something that's kind of intuitive and happens in almost every case on some level. But the question is, from the perspective of Jewish law, why does that happen? If in fact we're confident that the Torah is all-inclusive and that the Shulchan Aruch really should have the answer to any kind of controversy in play, why should secular law play any role at all? So the first thing many people kind of think of when they think about the incorporation of secular law in halachic thinking is the concept of dina de malchusa dina. Dina de malchusa dina was first articulated by Shmuel, who is an Amora. He's one of the sages of the Talmud. And usually, in most of the instances where it comes up in the Talmud, it's talking in a very narrow way about ratifying instruments such as contracts. Certain types of contracts benefit from dina de malchusa dina. If in fact the law of the land and the secular courts accept this as a formal mode of transfer, so then halacha will view it as such as well. More recently and colloquially, when we think of dina de malchusa dina, we think of kind of a personal moral mitzvah obligation to abide by the law. And even when the law is not something that's articulated in the Gemara or in our own codes. So for example, there's a halachic mandate to abide by speed limits. It's dangerous to violate speed limits, but it's also illegal to violate the speed limits. And so it's arguably a violation of dina de malchusa dina to speed, or at least to speed too much. It's dina de malchusa dina is also something that comes up when we talk about taxation. The authority of a government to tax its subjects, of a king or even in a democracy, whatever the mode of government is, halacha recognizes the ability of a taxing authority to tax and to impose taxes based on dina de malchusa dina, and whatever the theory for that is, that itself is a dispute among the Rishonim as to why that should be. You could think of other instances where dina de malchusa dina plays a role. For example, the prohibition against insider trading has no specific direct precedent in halacha. The Shulchan Aruch doesn't contemplate the kinds of financial markets that we have today in terms of their complexity and in terms of the anonymity of buyers and sellers. And yet we're all expected from the perspective of halacha to abide by the rules that prohibit insider trading, probably because of dina de malchusa dina, among other things. But dina de malchusa dina, if we're going to apply it to our topic tonight, is slightly different, because our topic tonight involves disputes among Jews. And if dina de malchusa dina allows the government to tax, it prohibits you from doing insider trading or from violating the speed limit, it's not as clear that dina de malchusa dina has any relevance to defining the respective rights and responsibilities of parties vis-a-vis each other when it comes to interpersonal disputes. Meaning, dina de malchusa dina has a lot to say about my relationship with the government and my obligation to abide by its laws, by its criminal laws, by other laws. But arguably, dina de malchusa dina, which stands for the proposition that you have to follow the law, plays less of a role when it comes to disputes between people. And in fact, the applicability of dina de malchusa dina to disputes between people is the subject of a dispute between the Ramah and the Shach. The Ramah says that we apply dina de malchusa dina very broadly, and any law that kind of makes sense, that it's l'takanas b'nei Medina, he'll apply it even to disputes between Jews. He talks specifically in one context about how long you have to hold on to a mashko and how long you have to hold on to security for a loan before you sell it after the borrower defaults on the loan. But the Shach disagrees, and the Shach says, interestingly, that Dina de Malchusa Dina only applies to disputes between Jews where there's a lacuna in halacha, specifically in a case where there's a gap in halacha's treatment of a specific topic. So if you have a case before you and you're a judge in a Beit Din trying to figure out who's right and who's wrong, and you flip through Shulchan Aruch and you just can't find the halacha, it doesn't exist, the Talmud doesn't address the topic at hand, that's when the Shach says, Dina de Malchusa says, okay, halacha doesn't address the issue, now turn to secular law and see what secular law says about it. There's a whole discussion among authorities as to when Dina de Malchusa Dina applies to issues between Jewish parties and in Beit Din. I'll tell you this, that as a matter of normative practice, the position of the Chida and this a Rabbeinu Yaakov Yosef, who's quoted in the Beis Yosef, who was the author of the Beis Yosef, is the author of the Shulchan Aruch, very often gets a lot of attention, and that is the following approach. The Rabbeinu Yaakov Yosef says that Dina de Malchusa Dina will be relevant to disputes between Jews if the government mandates that rule, meaning if you're not allowed to contract around or agree to terms at variance with that rule. So most laws on the books that affect interpersonal commercial matters, you could contract around, right? The government says that if you want to foreclose on property, you have to give a certain amount of warning to the other side, or you have to give them a right of redemption. You could pick any odd monetary law on the books. And generally speaking, if two people agree to contract around that, they agree to contract terms that are at variance with that secular law, they're allowed to do so. The courts won't have a problem with that. The court will respect the contract. There are a few secular laws where you can't contract around them. Can anyone think of an example of a secular law that affects monetary relations between two people where the government just doesn't let you contract around them? So the issue where this probably most often comes up in Beit Din is brokerage agreements. A broker, a real estate broker, at least in New York, I don't know what the law is in Connecticut, but at least in New York, you can't collect a commission on brokering a real estate transaction, unless you're a licensed broker. And the reason the government has that rule is because it wants to ensure that there are no shenanigans, or it wants to cut back on the shenanigans in the marketplace. It wants to be sure that anyone actively involved in brokering real estate deals is licensed, can potentially lose their license if they misrepresent things, or if they misrepresent things, or if they have conflicts of interest. So you can't, even if you agree to pay a brokerage commission to someone who's brokered a real estate transaction for you, if they're not licensed to be a broker, you can't contract that out. You can't pay them. So the practical import of that is Dina de Malchusa Dina will say that if you have a brokerage dispute in Beit Din and the person seeking the brokerage commission is not licensed to collect brokerage commissions, applying Dina de Malchusa Dina, the Beit Din might very well conclude that regardless of what Jewish law says in this particular matter, secular law trumps based on Dina de Malchusa Dina, and you can't collect the brokerage commission. But let's move beyond Dina de Malchusa Dina, because there's a whole other way that secular law creeps into or maybe not creeps, maybe floods into the Beit Din process, setting aside Dina de Malchusa Dina. Let me illustrate this by sharing with you a tshuva from Rabbi Moshe Feinstein from 1957. Go back to the screen. Here's what this is Rav Moshe Feinstein dealing with the question of the Socher. This is in Choshen Mishpat Siman Ayin Beis, dating back to Tafshin Yud Zayin. he says the following. He's talking about Besocher she'eno rotza latzeis mishum shekenu din hamedina v'maschir tzarech habayis latzmo. He's dealing with a dispute between a landlord and a tenant where the term of the lease ended. So under Jewish law, and intuitively you'd think if the term of the lease ends, the landlord should be able to evict the tenant from the property and now retain possession and move in himself or rent it out to someone else, because the lease only goes for a certain term. And once the lease term ends, that's it. The contract's over, the lease is over. You should be able to throw the guy out. But New York, or at least New York City, has what's called rent regulation, where at least now I think the law is that if we're talking about a property of 6 or more units, so let's say your typical apartment building, you can't just throw the tenant out at the end of their lease. You can negotiate a new lease, or if you fail to do so, they continue to retain their occupancy rights as a month-to-month tenant. As long as they continue to pay you the rent, you can't throw them out. And a dispute arose between a Jewish landlord and a Jewish tenant in the 1950s, where the landlord wanted to throw the guy out because his lease had expired. He wanted to move in. And the tenant said, you can't do that because under secular law, there's something called rent regulation. And just because the lease ends, you don't get automatic possession of the property. I took the liberty of translating Rav Moshe Feinstein's tshuva, or at least a portion of Rav Moshe Feinstein's tshuva, because it's you can appreciate some of the language. First of all, and he makes the distinction between Dina de Malchusa Dina, which is the doctrine that we just finished talking about, to kind of the next thing, which is Minhag HaSochrim, which is kind of the back doorway of getting secular law into play in Beit Din. So he says, with respect to your long treatment, he's addressing this to the Shoel, to the rabbi who had presented the question and proposed an answer to Rav Moshe based on Dina de Malchusa Dina. The Shoel suggested that perhaps the secular law with respect to rent, with respect to leasing, to the lease, to the ability to evict, should apply based on Dina de Malchusa Dina. So Rav Moshe Feinstein says, with respect to your long treatment regarding Dina de Malchusa Dina, it's difficult to write on this topic for 2 reasons. One, because there are lots of disagreements. It's all very controversial. There are contradictions. It requires great time and study. It's too hard for me, says Rav Moshe Feinstein. I'm not going to get into Dina de Malchusa Dina. That's too complicated. Second, interestingly, this is fascinating, he says, because we shouldn't be seen, God forbid, as if we are belittling the honor of the government of our country here. Rav Moshe Feinstein apparently was afraid of putting in print anything that would imply that you don't always have to follow secular law to the nth degree. He goes on to talk about how generous this country is to our Jewish brethren. We bless and pray them and pray to God at all times for the peace and safety of this country and its leadership. It's a nice paragraph by Rav Moshe Feinstein. But then he gets into the crux of the issue here, and he says that even beyond Dina de Malchusa Dina, there's a very good reason why you should apply secular law. He says, in my view, in this instance, where the law is that the landlord may not evict the tenant even after the term of the lease is expired, so long as the tenant wishes to remain there. The issue is in Dina de Malchusa Dina. Now you can skip a few lines. He says, but where the lease was entered into after the law was already in effect, meaning when these two parties entered into a lease, both knowing that New York law doesn't allow you to evict just upon the expiration of the lease, and they didn't expressly provide for the ability to evict at the end of the lease term, but the lease was silent on this issue, then it is as if they expressly agreed to abide by the law of the land, and the 2-year term in the lease meant only that the tenant may not exit the lease prior to its expiration, and therefore it is also considered at the time of the lease under Torah law. What Rav Moshe Feinstein is saying here is that even if you don't think that this is a case where Dina de Malchusa Dina should apply without question, there's a separate doctrine that takes hold and that's very relevant to disputes between Jews, and that is the concept of Minhag HaSochrim, that where people enter into agreements or enter into transactions or relationships with a certain expectation that secular law will govern, because that's what everyone does, because that's kind of the norm of the marketplace. So then that's what should govern disputes that arise between Jews. And so he uses this doctrine actually to rule that in this case, just because the lease ended, doesn't mean you get to throw the guy out. He can't be evicted. He has a right to stay there, consistent with New York law. And Rav Moshe Feinstein ends off by writing, it's considered within the time of the lease under Torah law. Torah law actually incorporates secular law to the extent that the parties intended, or can be, you could kind of infer or intuit that they intended based on the fact that they didn't say otherwise. They're operating in a secular marketplace where this is the way everyone does it. You can imagine we have an apartment building here with multiple units. So what Moshe Feinstein is saying is that if this landlord's lending out to multiple tenants, each one understands that they're doing this in New York. And just because my neighbor is Jewish or my neighbor is not Jewish doesn't mean that different laws apply. It's general expectation. There's a custom that applies, a norm that applies. And when we enter into a lease agreement, we do so with the expectation that that norm will apply. Now, Rav Moshe Feinstein didn't make this up out of nowhere. He didn't make this up in 1957. This has ample halachic precedent. In fact, it goes back to a Mishnah in Baba Metzia. The Mishnah on Daf Pei Gimel and Baba Metzia says, "Hasocher es hapolim." If someone hires workers, v'amar lehem hashkim la'ariv, and he tells them to get up early and work from an early time, or work very late. So then it says, "Makom shenagu shelo hashkim v'shelo la'ariv eino rashai." He's not able to impose conditions on them where the custom, where the norm of that region is otherwise. The understanding here is that this is a person who hired laborers. He did so perhaps with a contract or with an agreement, an oral agreement that didn't go into detail about when they would start, when they would finish. And the Mishnah says that the fallback arrangement is to follow the minhag hamadina, to follow the custom of the local, follow local custom. And this is based upon a concept that appears elsewhere in Bava Metzia. In fact, I think right around here, right around this stuff, of kol tanai shav mamon kayim, that people are allowed to enter into contracts and to agree to terms that might be sometimes at variance with the baseline halacha. Kol tanai shav mamon kayim says that you could agree to whatever terms you want, and halacha will actually ratify those terms as if it's halacha itself. We'll respect contracts. And so implicitly, we assume that when people enter into agreements or enter into business relationships with each other in the context of a secular marketplace, they implicitly agree to abide by the terms of the secular marketplace. In the rules and procedures of the Beth in America, one of the other unique features of the Beth of America is that we have published rules and procedures. It's available on our website that spell out, the process that when we handle Dinei Torah. So one of the rules that we have actually articulates this point. Here's an excerpt from the rules and procedures of the Beth America, sections 3D and E. And it says explicitly, in situations where the parties to a dispute explicitly adopt a choice of law clause, either in the initial contract or in the arbitration agreement, and just for the uninitiated, those non-lawyers on the listening here, a choice of law clause is in a contract that you enter into. One of the provisions in the contract might say that in the event of any dispute that arises under this contract, we agree to be bound by the laws of the state of Connecticut, or we agree to be bound by the laws of the state of Delaware or New York, whatever it is, and that's viewed as binding. And so what Section 3D of the Rules and Procedures of Beth in America says is that Beth Din will respect that as well. And it's based on this concept of kol tanai shav mamon kayim, that explicit agreements between the parties are viewed as binding. But then it goes on and says in E, in situations where the parties to a dispute explicitly or implicitly, even implicitly accept the common commercial practices of a trade, profession, or community, whether it be by explicit incorporation of the standards, initial contract, or through an implicit adoption, you might be able to just tell from the circumstances, then the Beth Din will accept such common commercial practices as providing the rules of decision governing the decision. We will respect a choice of law provision that's explicit, but will also be guided by our assessment of what the parties implicitly agreed to when they entered into the transaction. And then the question for the dayanim, for the arbitrators who are hearing the case, becomes, well, how do I know what choice of law or what commercial norms the parties expected to incorporate in their agreement? And that becomes just an assessment of the reality of the circumstances that brought them together. So for example, if you have two people who are negotiating and then even closing on a sophisticated business deal where the people conducting the negotiation are lawyers, so then it's probably true that everyone's expectation was that Connecticut law would apply if they're doing their business in Stamford. If on the other hand, it's two people in shul negotiating borrowing a car, so it's a little less likely that their expectation was that Connecticut law would govern, although maybe even so, their expectation is that Connecticut law will govern. For example, if one guy borrows another guy's car and they're all adults, they understand that insurance is very relevant to issues of liability. If there should be a car accident, then probably they expected that Connecticut law will govern in terms of insurance coverage and in terms of liability vis-a-vis one to the other. If on the other end they are negotiating some kind of sale of so just some something in one guy's garage today, one guy's selling his old lawnmower to the other. So I think then it's much more likely that they're not necessarily thinking that Connecticut law is going to govern their transaction. It's more likely that Choshen Mishpat, that Jewish law is going to govern their transaction. A lot of times it depends on the size of the transaction. It depends on the context in which the transaction is negotiated, on the sophistication of the parties and of the lawyers that are involved. We had a case years ago involving a fairly large real estate deal where you'd expect that in a real estate deal, probably everyone's expectation is that secular law is going to govern. But these were kind of very Hamish people. And the negotiation took place in some basement in Brooklyn with rabbis in long beards conducting all the fine points of the negotiation. And in that scenario, it seemed pretty clear to the Dayanim that New York law shouldn't have that much to say about this. If one of the rabbis was holding on to escrow money in cash in some safe, probably the laws of Choshen Mishpat were more relevant to this. I see there's a question in the chat. Let's just see. Yeah, does Bezin look for Dayan who are likely to know the second brother was Joseph? Yeah, the answer is I mentioned earlier that on any given case any commercial case, let's say at the Beth Din of America, there's at least one lawyer on the panel, and that lawyer will often take the front and center row and kind of asking the questions and working his way through the deliberations, because very often, as we're mentioning here, secular law will have a lot to say about the case. There's some cases, interestingly, where secular law will have relevance to one aspect of the case, but not another aspect of the case. If you can imagine a scenario where it's not necessarily going to be a secular-oriented transaction. Let's say it's a negotiation between parents and a school about tuition, and it's a yeshiva, and perhaps there Jewish law should apply rather than secular law. Or again, any commercial transaction where it's kind of more of a Hamish arrangement without lawyers and people just kind of winging it on their own and negotiating it in, as they're wrapping up their talisim and tefillin at the end of davening. So that's going to be, something that probably halacha is going to govern. But let's say that as part of that whole transaction, we had a case like this years ago where there was a whole transaction, and then the case turned on the fact that at one point, one of the parties paid the other party partially, meaning not the full amount that the guy was claiming, but a partial payment. But on the back of the check, or on the front of the check in the memo section, he wrote in full satisfaction of all claims. So the guy who received the check, I think, said that he was just handling his check, or he didn't even see the check. His secretary was handling the check, and no one was paying attention to the checks, and they just signed the back of the check. And so his argument was that as a matter of Jewish law, what were we talking about here? We're talking about mechila. Mechila is waiver, right? So the defendant was arguing that the plaintiff waived his claim by virtue of signing the back of the check that said in full satisfaction on the front of the check. The plaintiff said, I didn't waive my claim. That was a mechila betos. Shulchan Aruch talks about the fact that sometimes a waiver is made haphazardly and without full intent. If you make a waiver haphazardly and without full intent, so halacha recognizes that sometimes people kind of aren't paying attention. And in order for a waiver to really be true, you have to be focused on it. You have to do it with real seriousness of purpose. And he says, I didn't even sign the back of the check. My secretary signed the back of the check and then deposited it in the bank. And as a matter of Jewish law, the full satisfaction language has absolutely no relevance to the outcome of this case. Nothing to talk about. And the other guy said, I paid you with an instrument that's governed by Article 8 of the Uniform Commercial Code. And the Uniform Commercial Code, which is adopted, in all 50 states, some variation of it, says specifically that when someone writes in full satisfaction on the instrument, and then I sign it, whether my secretary signs it or whether anyone signs it, unless I repudiate my signature within 90 days, I'm deemed to have satisfied the obligation. The full satisfaction language works, and you don't get to use it as a defense that this is just a mechila betos that I haphazardly defended. So here we were dealing with a transaction that was Hamish in the one sense, where you'd expect Jewish law to govern. But on the other hand, they used a very secular instrument, a check, to pay. And I think the Dayanim came to the conclusion that as Hamish as these guys were, a check is a check. And when you're trying to figure out kind of how a check works or how people expect checks to work, it should work in the way that checks work in secular society. And everyone who signs and deals in checks does so with the expectation that Article 8 of the UCC, whether they know what Article 8 of the UCC is or not, will govern their use of checks. And therefore, in this case, that full satisfaction language was deemed to have extinguished the full claim. I think it's an interesting issue, and you could kind of argue both sides of the case. You could say, look, these guys never expected secular law to govern. They never heard of Article 8, and therefore we should maybe set that aside and look at what the full intent of the parties was and whether this was really a mechila betos. Or you could say, no, I'm a stickler for Article 8, and if they were paying with checks, they should abide by all the rules that apply to checks, and that's what should govern the outcome of the case. It was an interesting example of a case that might be split, where you might have some elements of the case decided based on Jewish law and some elements of the case decided based on secular law, because the people knew what they were getting into when they used the check. Let's see, I don't want to go over my time. I'll talk for a few more minutes and then we could kind of open the floor to questions. Another area where, let's actually see, there is a question. Isn't the first case similar? The client had said that his contractor made the holes in the cabinet and didn't get the chance to inspect the cabinet. This is a great question, actually. I thought about this. When we issued that decision about the kitchen cabinets, was it useful or relevant to look in Shulchan Aruch about the case? Meaning, this is an interesting academic question. When you're deciding commercial cases under Jewish law, do you first look at what halacha says and then kind of go through an analysis of whether these parties intended for secular norms to govern their transaction, and then do an analysis of secular law? Or maybe you don't even look at Shulchan Aruch to begin with, and you go straight to secular law. The case of the kitchen cabinets, I think, was a clear case where there was consonance or parity between secular law and halacha. Halacha, as you saw, said that once you take delivery, once you accept delivery and you put a hole in the cabinet, there's nothing to talk about. You've accepted delivery and you don't get to return the cabinet. And I think secular law would say the same without looking up what the UCC says. I think intuitively, at least I think intuitively, tell me if you think otherwise, once you accept your kitchen cabinets for delivery, there's no lawyer in the world or no business person in the world who's going to tell you that the norm in the industry is that you could return the cabinets based on a clear defect that was discernible before you drilled the hole into it, that you can nonetheless, demand that the merchant take back the cabinet. I think once there's a clear defect in the cabinet and you accept delivery and then install it, it's kind of too late. Maybe it's good business practice for the merchant to come and try to fix it up, to try to accommodate. Maybe you could take that door off and return it. That's a different story. But once we're talking about merchandise that's clearly accepted, that has holes drilled into it, it's common commercial custom, I think, to say that you took it and you don't get to complain anymore. And so that's an example where I think you would have come to the same result anyway. So Diana didn't even need to go through an analysis of any distinction between Jewish law and secular law. I see Phil Shapiro saying usually two cabinets. No, this was a case where the cabinets, he took delivery of the cabinets. They're sitting on the floor of his kitchen in the middle of its renovation. He has an opportunity to inspect them, and he gives up that opportunity, and he tells his contractor, just start drilling, just start putting the cabinets in. So there's a situation where he had the opportunity to look, and he declined to do so. Okay, our discussion about kind of the ways or the laws that are in play when cases come to Beit Din. So one of the things that we talked about was Dina d'Machus Dina, and to what extent secular law might kind of in a mandatory way apply. Then we talked about Minhag HaSochrim, about the ways in which parties sometimes implicitly or explicitly accept upon themselves secular laws or customs to determine the outcome of a case. Related to the concept of Minhag HaSochrim is the concept of situmta. Situmta is a concept that appears in the Gemara, where normally, in order to transfer title to an item, you have to do what's called the kinyan. You have to perform some type of symbolic act to signify to both parties that you used to own this property and now I'm taking possession of this property. Sometimes that could be the trade of a handkerchief, like you might see at a wedding where the chassan accepts the obligations of the ketubah by raising a handkerchief that the rabbi hands to him. That's a symbolic act of a kinyan by which he accepts an obligation. And so halacha says that even though you might need a symbolic act like the raising of a handkerchief in order to transfer title to something, halacha recognizes that if there's a certain customary mode of transfer in the marketplace that is not listed as one of the modes of transfer in the Gemara in halacha, nevertheless we will accept that as a mode of transfer to transfer property. And the reason for that is because the whole reason why you need a kinyan altogether, why you need some kind of symbolic act altogether, is to evidence gemirut das, which is to say that your intent is to transfer title. This isn't just a kind of flippant idea that you have, oh, you could have my sofa. In order to actually evidence gemirut das, to evidence intent to transfer it, I need to do something symbolic to make it clear that I'm actually transferring title. And so if there's a custom in the marketplace that offers a different mode of transfer, halacha will recognize that mode of transfer. It's not just for transferring, but it's also for undertaking an obligation. So for example, if New York law or Connecticut law says that you could assume an obligation by signing a contract, assuming there's an offer and an acceptance and consideration and all the elements you need for a contract, so halacha will recognize a contract as binding, even in a situation where halacha might not have allowed that contract to be binding. And so, kind of to take this concept a step further, and this is something that comes up very often in Beit Din, there are some contracts that are not enforceable under Jewish law. A famous example of this that would pose a real problem in Beit Din nowadays is the concept of a davar shelo bali olam, something that doesn't exist yet. So if I enter into a contract with you to buy wood that has not yet been harvested and processed, it's still in the forest, and I'm entering into a supply agreement with you to buy wood that in a year from now, and we all know that the wood doesn't exist yet. So under halacha, arguably, that contract is not enforceable because it covers a davar shelo bali olam. It covers something that's not in existence yet. And halacha views it as not being a serious agreement, not being a serious commitment for me to buy or sell that wood because it doesn't exist yet. In the 18, like a futures contract, yeah, someone pointed out, this is obviously, if this law, if this halacha was relevant to contemporary Beit Din adjudication, we'd be in big trouble. Or maybe we wouldn't be in big trouble. We would just, end up getting bizarre answers to, from the perspective of a person in the marketplace. If we applied this halacha literally, you'd have to throw out any kind of supply agreement that involves merchandise that has not yet been produced. You'd have to throw away any kind of futures contract. But luckily, in 1821, the Chassam Sofer, who was then the preeminent posek in Europe, issued a tshuva in which he addressed the issue precisely of the example that I just gave, of someone who had entered into a contract to buy lumber that had not yet been harvested. And the Chassam Sofer argues that based on this concept of situmta, of common commercial custom, the idea that you could evidence gemiras das, intent to buy or sell, by adopting a mode of transfer or a mode of undertaking that's common in the marketplace, and that itself will evidence the requisite gemiras das, the requisite intent to abide by a contract, that's sufficient. And so therefore, even though this contract might not have been enforceable under the letter of the law of halacha because it involves produce, lumber that has not yet been produced, the Chassam Sofer ratifies that contract under the concept of situmta, that where common commercial custom is to allow for such a contract, he'll ratify it. That's an important kind of footnote to the concept of minhag hasochrim. It works not only to think about which body of law and which customs to take into account, but also to ratify transactions that halacha itself might not be fond of, or might not have ratified. All right, there's a lot more to talk about on this topic. I didn't even get into another topic that I was going to get to, which is Pshara Krov Adin, the extent to which dayanim, similar to secular law arbitrators, are able to kind of round the corners based on equity. If abiding to the strict letter law of the law will lead to an inequitable result, or something that just doesn't make sense at all. So arbitrators, dayanim, arbitrators in the secular system, judges have the ability to apply equity into the mix. So dayanim have a similar ability, and that's a whole other topic of discussion, but maybe we'll have the opportunity to discuss that sometime in the future. I want to just, let's see, there's another question that came up on the discussion board. Bezdin is going to analyze the case based on secular law. Dayanim are not all judges trained in secular. What is the reason of taking a chance that dayanim might get a waiver as a secular court? Who's not going to our cause at that point? Well, the answer to the question is on a very simple, basic level to start with is there is the prohibition against going to secular court. That's a real prohibition. And to answer the first problem is that, that's why the Beth Din of America kind of exists. People worry about Beit Din and critique Beit Din for not being sophisticated and not being able to grapple with secular law treatment of complicated commercial issues. The answer to that is the Beth Din of America. We were established, and we've established, I think, a good reputation for bringing that level of sophistication to the cases that we handle. And that's why in any given case, there's going to be at least one lawyer on the panel who knows how to issue spot, who knows how to work his way through those issues and issue a decision that does make sense. We have a tracker. We actually, on our website, we have, one of the problems that we have is, we'd love to kind of just publish the decisions that we issue because we think they're good quality decisions that speak well for our process. The problem is because of confidentiality, we're kind of we're limited from doing so. But in a number of cases, we've been able to get permission from parties to anonymize the case by changing some names and then publishing. We have about a dozen actual decisions on our website. And we're trying to constantly come out with more. So it's worth, if you want to take a look at that. Okay, so Toby Schaffer.
Yeah, going back to this last question sort of relates a little bit to my question. What I was really trying to get at is, let's say if the issue at bar is not just secular, but it's specialized secular. Let's say if it's intellectual property law or it's Greek law, or, you know, let's say the parties have in their agreement that we're going to apply Greek law. Does the Beit Din go and find a lawyer that is versed in those, you know, specialized areas or those kinds of law, or are you just left with a lawyer?
I would say that if we were talking about a specialized area of law, that, you know, Greek law is an example where I think I'd figure out how to find a Greek lawyer. It might be tough to find, but, you know, either as a consultant to the Beit Din, you know, Greek law, I don't think I can wing because I just don't know Greek. You know, whereas Connecticut law, I could wing. I'm admitted to the bar in New York and New Jersey, and Connecticut law, especially, you know, in any level, in any case of any level of sophistication, the parties are going to be lawyered up. They're going to come with their own lawyers who could brief me on what the law is. And with my background and training, I could kind of make my way through Connecticut law. I think that's true about some specialized areas of law as well. And so therefore, we would usually rely on our own in-house talent pretty much across the board. I would say that if parties came to the Beth in America and said, look, we're just not comfortable relying on a general lawyer to delve into this, and we really want a specialized lawyer, we would work with them and either get a specialized lawyer to consult with the panel, or if they're qualified to sit on the panel. But I would say, look, your average judge sitting on a case doesn't necessarily have the specialized knowledge unless they're talking about a specific specialized kind of court. But, you know, the answer is we would generally either, if we realize we're way out of our element, like Greek law, we'd figure that out on our own. Otherwise, we'd wing it with our generalized knowledge, unless the parties had a request that we kind of bone up or join a specialist that we could work with the parties to do that. Quite a good question. How? Well, first of all, before the last question, I just see the BDA. Does the BDA offer an option of only lawyers as they am? That's another area where we could work with you. Meaning, if the parties are kind of having difficulty swallowing the concept of coming to Beit Din because you know, they're giving up on their court rights and et cetera, and it's just an unfamiliar terrain, and want that comfort of knowing that the panel is a panel of 3 lawyers, we could work with the parties. We have enough lawyers on our roster that we could accommodate that. The next question is a great question. How are you financed? We're financed by a combination of community donations that mostly come from board members, shuls. I'm happy to say that that your shul is hopefully a proud sponsor of the Beth Din. You know, we run a campaign each year of getting donations from shuls across the country, with each shul donating an average of a few $1,000s. The donating shuls are all listed on the back of the prenup, which is if you go to the prenup website, theprenup.org, you could see the list of donating shuls. So it's a combination of donating shuls, donations from private individuals who are almost all board members of the Beth Din of America, and support from the Orthodox Union, which supports us, which sponsors us, and then fees from services, from money that we make from charging fees for Dinei Torah that we do and for Gittin that we arrange. And whenever there is a case, we disclose any potential conflicts. So for example, if someone knows a board member who makes it, you know, each of our board members donates an average of about $2,500 a year. So if someone knows a board member, or we know that someone has some kind of affiliation with any donor, that's always disclosed and waived, and or you know, we will staff the case with neutrals. We work through the issue in full transparency with both parties.
Rabbi, I have a question for you.
Yes.
So, at least in my experience, not whenever, but many times there might be a conflict. And I mentioned Beit Din of America, and people say, no, we can't go to the Beit Din. We have to go to the secular courts. So to a certain degree, I felt it's been an uphill battle in getting people's heads wrapped around saying that if there's a conflict, be it within a Jewish organization sometimes, which happens, that Beit Din of America is the right address. Have you seen trends towards a greater acceptance of the Beit Din of America's role, an increase in cases? What are some of the obstacles, and maybe how can we be helpful? Because obviously, you know, you do offer a very important service, but I would imagine that there's so many more people that could be using the Beit Din that are not using the Beit Din.
Yeah, it's a great question. We've seen trends. Let me say, first of all, that there are a few ways to kind of address the issue. First of all, there are some benefits to arbitration generally over the courts. There's the efficiency of the process, the speed of the process, cost savings from having to hire lawyers that are going to litigate for, you know, potentially many months or years in court. So there's kind of, aside from the halachic propriety of coming to Beit Din rather than going to court, there are practical reasons why it's a better or preferred forum. There's, you know, we've just spent the last hour talking about kind of the role of secular law in Beit Din and the sophistication. I hope I've to some degree kind of showcased or talked about that the Beit Din of America has in furnishing lawyers who sit on the cases. So to the extent people are concerned that their case is just too complex for, you know, rabbis who are not necessarily trained in this or aren't used to seeing joint venture agreements that run on for 50 pages or syndication agreements or whatever, you know, what have you, we have that sophistication and we have that experience. So I think, you know, part of the approach needs to be kind of communal education, kind of like what we're doing tonight. In terms of the trends, they've been positive. We now have, you know, when we first started, I would say very actively handling commercial cases with lawyers on board in the late 1990s, early 2000s, we were probably handling about 30 files a year. When I say files a year, it's not necessarily 30 cases that are actually adjudicated. It's cases where we've been asked to send a summons or we've been involved in mediation or somehow involved. We were handling probably about 30 cases a year. Now we handle in one form or another an average of about 150, 160 cases a year. Again, that's not to say we actually arbitrate with arbitration agreements 160 cases a year, but we have 160, I think last year we had closer to 170 files open. Actually, last year was a little down just because of the pandemic, but 2 years ago, files a year where we're involved in some level, mediation, sending out summons. But again, it indicates an interest in the community in bringing the cases. And probably of those numbers, we actually arbitrate about 25% of those numbers. But that's a number, as you can see, it's just the trend is upwards. We're hoping to continue to keep the trend up. And I think one of the reasons the trend is up is because of word of mouth. Lawyers who have brought cases to us, who have represented parties in front of us, have been impressed with the level of sophistication of the dayanim, of the proceedings, of the decisions. They're well reasoned. We decide them on the merits often based on secular law, based on halacha, based on combination, but we get the right answer, hopefully more often than not, or much, much more often than not. And we do it with reasoned opinions. You know, the decisions that we issue go into the facts in a cogent way, in a clear way, explain, like you saw in the little excerpt that I showed you at the beginning of this evening's presentation, explain the basis for the decision. We have kind of good, rigorous rules and procedures that govern the process. We're very careful about those procedures. There's no ex parte communication. There's, you know, we kind of have a lot of procedural oversight and regularity. I oversee each case. I'm an attorney by training and kind of bring that background to the fore. So I think that in large part explains the increase in the numbers.
Thank you. I know Phil Shapiro had a question that was on my mind as well. It's in the chat. If a person doesn't want to go to the Beit Din, the notion of somebody refuses to go to a Beit Din. Yeah,
so this is a complicated area that, but the bottom line is, you know, at a plaintiff's request, or at a party's request, we will send a summons out. We'll follow it up with a second summons, a third summons. If the other party explains to us why this is a case that shouldn't be in Beit Din for some procedural reason, we will analyze that and kind of work that through. If at the end of the day, someone has a bona fide claim, there's no good reason not to be in Beit Din, and we go through the process, we could, in some limited circumstances, issue a seruv, which is a document of contempt, which simply says that the person is not abiding by their obligations under Jewish law to appear in front of a Beit Din. Someone who receives a hazmana summons has the right to choose a different Beit Din. There's a whole process that plays out to ensure fairness in kind of choosing the Beit Din. But that's the answer to that question. What happens in cases like car accidents where the party is willing to go, but the insurance company, which is not Jewish owned, will not? Yeah, that's a good example of a situation where a seruv would not be issued. We would not force a party to come to Beit Din in a situation like that where there's insurance coverage. Based on Jewish law analysis, meaning under Jewish law, the insurance company is viewed as the real party in interest because insurance is common and expected in our landscape, in our economy. And therefore kind of everyone driving their car out there, or everyone walking into a supermarket and at risk of slipping and falling knows and is on notice that insurance coverage might be expected, might very well be expected. And therefore, as a matter of Jewish law, the defendant has the right to interplead their insurance company, so to speak, and make them party to the action. So as a matter of Jewish law, the insurance company is viewed as the party in interest, and the plaintiff doesn't have the right to go to Beit Din. There's good stuff on our website that kind of goes through all of this. If you go to our blog, we launched a blog about 1.5 years ago called Jewish Prudence, which has really good, timely, and well-written articles and postings about all the ins and outs of all these kind of cases. We also, a few years ago, or several years ago, we launched the Journal of Beth in America, which has articles on this issue. There's one particular article by Rabbi Yaakov Feit about the prohibition of litigating in secular court, and it goes through all the kind of permutations and exceptions to that rule. It's worth reading if you have any interest in it. It's up on our website.
Thank you very much, Rabbi Weissman.
Okay, my pleasure. Thank you. Thank you very much for the opportunity. I really, really enjoyed the last week and this week.
Very interesting.
Definitely. Thank you so much. And continued good work with the Beit Din. We really love partnering with you, and look forward, God willing, to staying in touch. And again, as Rabbi Weissman offered last week, if anybody has specific questions, feel free to reach out to him. And again, chazak ve'amatz, and all the best. Thanks again.
Okay. Thank you. Thank you.
Good night, everybody.
Thank you.
Have a good night,
All right.
everyone.
Good night.